It's with so much pleasure that I get to introduce our next keynote speaker, Associate Professor Angela Morrison, who is a professor of law at Texas A&M University. And Angela is also one of our outstanding graduates from Utah State University. She graduated some time ago in history and in classics, and I know that some of her faculty are here to support her today. She was really an exceptional student and alum, and we're honored to have her back. Welcome back home. Also, I want to talk a little bit about Angela and her accomplishments, and you can read about her in the program. She has a great bio, and I do encourage you all to read it. I want to tell you a story that I don't think Angela is going to share with you today. I have been lucky. I grew up thinking that the law was a noble profession, and I still believe that. And I know that I get to work with some outstanding lawyers here on campus who are passionate about justice and equality. Angela is one of them, and I want to share a story. Of all of the stories I have about Angela, this is one of my favorite. When she was a third-year law student at UNLV, she was one of the leaders of the immigration clinic there, and on her way into work, she saw one of her clients, her immigration clinic clients, and he was handcuffed and pushed down on a police hood. And so Angela pulled over, third-year law student, looked in her purse, found her business card, approached the police car with her business card and her hand up like this, and said, "This is my client." And it just, we need more people to pull over their cars and not necessarily approach police cars, but to pull over their cars metaphorically and see other people. She walked up and she asked how long the person had been up against the hood, and he'd been there already for 30 minutes. He had been walking, he was about 3 miles away from where a crime had occurred, a robbery had occurred, and the description was that there was a Latino man who had robbed a place. So the police told Angela, well, your client fit the description, and Angela helped resolve that situation, and then gave her client a ride to the clinic where he had been going by bus. So that's the kind of person that Angela is, and I'm just so pleased. Thank you for joining us today. And to all of the rest of you, always feel free to pull over your car in times of need. Angela?
Thank you. I'm delighted to be here, and thank you for that wonderful introduction, Kristen. So one of the things that I do, as you heard, is immigration law. I also do employment or workplace law, and I got my start really as a lawyer working in the immigration clinic at UNLV. And I had this opportunity where a client who started with the clinic, who we were able to get refugee status for, he was from Tibet, and he was a Buddhist teacher and had to flee because he'd been imprisoned by the Chinese government. We were able to get him refugee status when I was a student attorney. Then when I went back to UNLV and actually taught in the immigration clinic, we were able to help him get his naturalization. So this is one of the happier moments I've had being an immigration lawyer and immigration attorney, and that's representing this client. This was at his naturalization ceremony with one of the law students who I was supervising at the time. So I always like to start with this because, again, there's very many happy moments when you're an immigration attorney or working, especially with the immigrant community, and I like to remember that. Okay, so what I'm going to talk about today, as you can probably surmise from the title of my talk, is I want to go over 5 myths of about immigration and immigrants, and to the extent I can correct those myths or say why I think that they're myths. Then I'm going to talk about why those myths matter, and then I want to just conclude with some thoughts about what we might do to be able to maybe not combat the myths, but at least ameliorate them. So we can create a more inclusive community for all of our community members. So the first myth that I'm going to talk about is the myth of the illegal alien. So there's really 4 main reasons why this is a myth. So the first reason really has to do with the fact that this is not an accurate legal term. The term illegal alien does not appear in the Immigration Nationality Act or in any of its amendments. The word alien does, but it's used in its sense of meaning the other or as a non-citizen. So that's the first problem with using the term illegal alien. The second term is it implies criminality. And the fact is that non-citizens who are here without authorization are not breaking any sort of criminal law. That's just a civil violation. Now there are some criminal, a federal criminal misdemeanor for entering without inspection. That can escalate to a federal felony for some people who've been deported and then re-enter without inspection. But just being here without permission or overstaying your visa is itself not a crime. It's a civil citation, civil violation. My third issue, or the third issue with using the term illegal alien, is the fact that illegal is imprecise for a number of reasons. So the first question is, to whom does this refer? Does this mean people who entered without inspection surreptitiously? Does it include people who overstayed a visa? So maybe they came in as a tourist or as a student and then overstayed that visa. Does it include people who have a form of immigration status but might have done something that technically makes them deportable? So let's say you have a legal permanent resident card. The law requires that you carry that card with you all the time. If you don't, that's a deportable offense. Is it something that applies to people who don't have official permission to stay or some form of immigration relief, but the government has agreed to exercise its discretion and not deport them? So that would apply to people like deferred action for childhood arrivals. The other thing that's imprecise about this term illegal is that these categories can change over time and apply differently in different situations. So someone may be here without authorization, but they could actually be eligible for some form of relief and not know it. They might be eligible for asylum relief. They might be eligible for special types of visas for victims of crime or trafficking. They also might be someone for whom they can, or who can seek a special form of relief in court called cancellation of removal. So again, this term is very imprecise. It doesn't really categorize who it is that this refers to. The third problem with using that term illegal alien is that generally our legal system and the law refers to acts or actions as being illegal. That we don't usually use that term, and in fact, this is one of the few instances that you hear that term being used to refer to people. So it applies that the very fact of that person, right, is illegal. And so what you'll see in my talk today is I'm not going to use that term. I'll be referring to people who are not US citizens or nationals as non-citizens, and then I generally will use the term unauthorized or someone here without immigration status, or be more precise in who it is I'm describing. Okay, so the second myth, non-citizens commit more crime. So that, of course, is a myth. Study after study shows that, to the contrary, non-citizens commit less crime than people who were born citizens. And this is true even in the studies that pull out people who are here unauthorized or without authorization and account for that. So I'm going to just quickly highlight 3 studies that have come out recently. So the first is a study that was done in Texas by the Cato Institute. You know, that really liberal progressive group out there? So they looked at criminality in Texas, and one of the reasons they chose Texas is because Texas is actually a state that's been tracking the immigration and citizenship status of everyone who's convicted in the state. And in fact, what the authors of the study stated is one of the issues with their stats is that people who are unauthorized might have even been double counted. So the numbers of crimes attributed to people without authorization in Texas are probably higher than what they actually are in real life. So what we can see from this, right, is that as would be expected, the citizens by birth were convicted of far more crimes than non-citizens. And even breaking it down, if you see citizens by birth, it's 1,794 criminal convictions. And again, this is for 2015. For people who are unauthorized, it was 782. And for all immigrants together, 458, and then for those with some sort of immigration status, it's 262. So that's one of the first studies, and that's based on 2015 statistics. This study just came out in 2018. One of the other studies is another study that came out in 2018, and this just looked at general associations. What this one discovered was that there's a general association with decreased violent crime rates and increased levels of unauthorized immigration. So this was looking at, you know, can we track it and say as unauthorized immigrants in a community, the numbers increase, are there more crimes? And this study said no. The third one that I want to highlight is one from 2015 that was a survey of other studies. And this found across all decades, in the last 30 years, the 80s, the 90s, and 2000, that it shows, right, that citizens or citizens by birth commit crimes at anywhere from 2 to 5 times higher than non-citizens. Okay, so the third myth that exists about immigration law or the immigration system is that there's a line to wait in. So one of the pieces of rhetoric or narrative that we'll hear a lot about immigration, right, is that people are jumping the line or that they should just get in a line, right, to wait for their immigration status. And there's 3 reasons why this isn't accurate. One has to do with the extensive number of grounds of inadmissibility that exist in our current law. So there's all sorts of reasons, anything from being convicted of, say, 2 shoplifting offenses, to being someone who's poor in poverty, and especially to being someone who maybe has been in the United States without authorization. That actually bars you from getting any sort of immigration status. It makes you inadmissible. So that's the first problem with the idea that there's a line that anyone who wants to immigrate can get in. The second one has to do with the numbers of immigration visas that are available. So the last time that Congress looked at numbers and set the numbers of visas available in our immigration system was 1990. So that's almost 30 years ago, and you know how much our population has increased since then. So at that time, it set the numbers for the 3 main programs: family-based, employment-based, and diversity-based visas. So for family-sponsored visas, there's 480,000 of those available in a year. For employment-based, there's 140,000. And then for the diversity visas, there's 55,000. Okay, so that limits the number of visas that U.S. can give out any year. Then there's another thing that goes into it that limits the numbers, and this is something that the 1965 Immigration Act created, which are preference categories. So you still have to fit within a preference category to qualify for one of these visas. So I'm going to go ahead and walk you through the preference categories for employment-based and for family-based visas. So the first is for employment-based. And what you're looking at right here, this is the Department of State Visa Bulletin. And what happens is this comes out every month. And this lets people know when visas are available, when you would have had to file for each of these preference categories for the visa to be available. And the other thing you'll note is that it's broken down by country. And that's because there's another aspect of immigration law that only allows the visas from any one country to only amount to 7% in a given year. Okay, so let's look at these categories. So up here, this over here refers to the different kinds of preferences. So in the first category are people that are considered of extraordinary ability. So that's people like basketball players, actors, famous ballerinas qualify for this. There's also outstanding researchers. I would like to consider myself an outstanding researcher, but the regulations, one of the things that they look at is, have you won a Nobel Prize? That might be something that qualifies you as an outstanding researcher. And then the third category are certain multinational executives. And so these are for people that are from these really huge corporations, a lot of responsibility. So very few people qualify for this first preference category. The second preference, maybe a little more reachable, but that's more for a category of researchers and professionals that have a degree beyond the baccalaureate degree. And so for those people, not only do they have to fit within that and say that they have this degree beyond a baccalaureate degree, but they also have to have an employer sponsor them. And then they also have to get a job or labor certification, the employer does, from immigration officials. And they have to show that they would not be able to hire a US citizen or a legal permanent resident to fill that job. So then we have the third category, and this is for skilled workers or what they call professionals. So that's for people who have a baccalaureate degree, or at least one, or 2 or more years of experience. And for that one, again, you have to have the job certification and an employer has to sponsor you. There's this other fourth category, or other workers here. There's 10,000 visas that are limited to people who don't have a baccalaureate degree, but you can see with 10,000 there's just not that many available in a given year for that. Then we've got this fourth category. It covers a lot of things not based on labor needs, but more about the particular needs of the immigrant. So you can see there's religious workers that kind of fall underneath that. There's this other category that has nothing to do with jobs that's for special immigrant juveniles. And then this fifth category is one for investors, and generally they have to be able to invest at least $1 million and employ at least 10 US citizens or legal permanent residents. So as you can see, the categories for employment visas, and there's only 144,000 of them even available in the first instance, are really limited. And then the other thing that you'll note is there's these wait times. So for some people from some countries, which I'll talk about a little bit later, is their waits are incredibly long. So if you're an unskilled worker and you were born in, say, China and you want to immigrate, the employer would have had to file the petition for your visa in 2007. Some of the shorter waits, right, are from 2 to 3 years ago, 17, 16, and then we see some that are currently available. So again, there's a lot of people who just aren't going to qualify on employment-based. So then there's this other category, family-based. Again, same thing, right? This is the Department of State Visa Bulletin that tells us about when visas are available for family members. So there's one category that's not on here that's not in the preferences, and those are for immediate relatives of United States citizens. But what qualifies as an immediate relative is very limited. So first of all, the first category is spouses. So spouses of United States citizens would qualify as an immediate relative. Children, but they have to be unmarried and under the age of 21. And then the other one is parents of United States citizen, but the United States citizen has to be 21 years or older. So that's a limited category. Now, for the other ones where the preferences come in and the visas start to get limited, this F1 category are the unmarried adult children of United States citizens. For F2A and F2B, those are relatives of legal permanent residents. All that count in there are spouses and unmarried children. In F3, those are the married children of United States citizens. And then F4, those are for the siblings of adult United States citizens. So, and the United States citizens have to be over the age of 21. Now you'll see here they all have weights. So unlike the employment-based system, there are weights for all of these visas. This one right here for the Philippines, if I wanted to sponsor my sister and she's from the Philippines, I would have had to file her visa in 1995. So I think at that time my sister was 7 years old. And I think I was 21, so I would have been able to file it. Okay, so but you can see that these waits are really long. So it's a very limited category of who qualifies as family members under the immigration system. So if you have grandparents who are raising you and who you consider to really be serving in the role of parents for you, you can't sponsor them. If you have aunts, uncles, cousins, you can't sponsor them. So what the immigration system views as family members may not be what we all view as important family members in our lives. And if you don't fall within any of these categories, you can't get a visa through a family member. The other two programs, or the other immigration program that I haven't talked about is the diversity one. There's 55,000 of those available. They're for undersubscribed countries, so countries that don't send immigrants can often get visas. There's only one in the Western Hemisphere, that's the Bahamas, and there's usually around 4 to 5 of those available in a year. And those have education and skills requirements. And you'll know I haven't talked about the refugee or asylee program. It's a kind of a separate set of laws, but for those, that's really hard to qualify for as well. You have to show persecution or a well-founded fear of persecution on account of your race, national origin, religion, political opinion, or membership in a particular social group. So the point of all of this is there's very limited ways for people to even be able to immigrate if they want to do so within the immigration system. So the idea that there's this line that people can just get in or apply for a visa, and if they're patient and they can wait and immigrate legally, is just inaccurate. Okay, so my third myth is my family came legally. Two ideas behind this. The first one is this may just be outright incorrect about your family. I don't know your family's immigration history, but it may just be incorrect. One thing that could have happened is your predecessors may not have come through the existing processes at the time, but because of the wide availability of regularization programs, also known as amnesty, they were able to get some form of immigration relief and regularize their status, right? They also may not be correct because they might have done something shady in the process, right? So my family story about that is I had a great-great-grandfather who immigrated from Italy with a group of other men, and they knew that to prove that they weren't going to become a public charge when they were inspected at the port of entry, they had to show that they had $5. So they all used the same $5 bill and passed it along the line to prove to the immigration officers, right, that they weren't going to become a public charge. So does that mean my grandfather, maybe even great-grandfather immigrated legally? No, right? He broke the law to get here. The other way is it might just maybe not be inaccurate, but it makes a bad comparator for what's going on in today's current US immigration system, right? So the idea that someone who immigrated even 40, 50 years ago is a comparator for what people have to do to immigrate now is just inaccurate. So I want to expand on both of those ideas a little bit further. The first has to do with the legalization programs that have existed throughout US history. And so for a lot of people whose ancestors maybe came here, they might not have, first of all, even come through any sort of a process, because until the 1880s, we had no restrictions on immigration. Then once there started to be restrictions, and especially starting in 1924, where the US established a consular system where people had to get visas abroad and also created border patrol, then there started to be an unauthorized population that we started to have in the United States. So what did we do? In 1929, the United States passed the Registry Act. And what the Registry Act allowed some people, of course, there were, and I'll talk about this later, but many folks were included, especially people who were Asian, from China, pretty much every country except the Philippines and Japan. But what they could do is pay a fee. It started out as a fee of $20. And if they showed that they were a person of good moral character, they were able to present themselves to immigration, register, get their permanent status card, and then get citizenship. So I also had a great-great-grandfather from Denmark who got his immigration status that way. Okay. And so that has continued until 1986. So the last time we revisited the Registration Act was 1986, and at that time, the date that Congress set was 1972 as the date you had to be here prior to. So there's actually people maybe who are here that were here prior to 1972 who could take advantage of the Registration Act still. Now, the other way that happens with these legalization programs are the things that we often hear referred to as amnesty. So the last time we had one of those was in 1986 with the Reagan amnesty. And with that amnesty, about 3 million people were able to get their status regularized. Okay, so that's about legalization. So this covers the people who maybe didn't go through the immigration processes that existed, but they were later able to avail themselves of these processes to gain status. Now, the other group I wanted to talk about were the ones who maybe use the process, but that are bad comparators for what's going on. And that's because they probably wouldn't qualify under today's laws. So the first thing, if you recall the preference systems that I just went through, if you're the first in your family to immigrate, it's going to be really unlikely, because family-based immigration is going to be your best shot, unlikely that you're going to fit in any of those employment-based categories, and you're not going to have a family member that can sponsor you, so you're completely out of luck. The other thing that's happened since 1986, and really amped up in 1996, was increasing numbers of bars of inadmissibility. So it's much, much harder to be admissible to the United States. There's also changes that Congress has made to the legal, to the court system for immigration, so that different forms of relief that used to be available, something called suspension of deportation, is no longer available to most people. So those are the reasons really why saying that my family came legally is often inaccurate, but a lot of times just not a great comparator. Okay, now the last myth, immigration laws are race neutral. So I think we all who have learned about it know, of course, that historically the immigration laws were explicitly and expressly racist. So they actually excluded on the face of the laws people of different ethnicities or national origins. So that started in the 1880s with the Chinese Exclusion Act. And that expanded to include, like I said earlier, almost all Asian immigrants except for those from the Philippines and Japan. There were explicit provisions put in the law to try to stem the flow of immigrants from Southern Europe in the early 1900s. So what this resulted in was a lot of quotas based on national origin or ethnicity and bars for particular races. The other bar ended up being on a lot of African countries too. So in 1965, a year after the Civil Rights Act was passed, Congress wanted to get rid of all of these race-based and national origin-based bars to being able to immigrate. So they passed the Immigration Act of 1965. And so it explicitly abolished the discriminatory national origin quota system, and it eliminated race, ancestry, or national origin as a basis for denying immigration. But even when they were passing it, supporters of the bill tried to get people who either were opposed to the bill or were weak supporters of the bill to support it by making promises, and even in the debate remarks to other senators, saying, look, don't worry, we're putting in these quotas or the caps on the visas, so you don't have to worry about an influx. And at that time, they picked out of immigrants from Africa or Southern Asia. So even in passing this bill, some of the motivations underneath it and some of the compromises that they made was to put these caps, right, on the number of visas, so that they would, what they said, make sure that the United States stayed racially balanced. Okay, so what I want to do, though, is highlight 3 ways in the laws that we have now, which on their face, like don't refer to race or national origin, are actually not race neutral, at least in their operation. So the first I started to mention, which is this preference system. So as you saw when I showed you the Department of State bulletin, did you notice anything about who has to wait for visas? So if you look at that, right, I'll go back a few slides. It's people from China, El Salvador, India, Mexico, Philippines, Vietnam. On the family-based, it's China, India, Mexico, Philippines. So in that way, right, these laws have a disparate impact, at least on people of this ethnicity or national origin, because they have to wait longer than other people. So that's the first way related to the preference visas. The other thing is at the same time that Congress was creating the preference visas, and even as recently as 1986, Congress did things like add extra visas for nationals from 36 countries. That's that diversity program I was talking about. And the majority of those are countries that are in Europe. Okay, so then the second way in which the law creates inequities based on race or national origin is that are these bars on admissibility based on unlawful presence. So one of the things that can make you inadmissible is if you've been unlawfully present in the United States. And how that works, it's either a period of 3 to 10 years that you have to wait outside of the United States before you're able to apply for a family-based or employment-based visa. Well, the way that they created that law in 1996, they included an exception for people who entered with an immigration visa. Who enters generally with an immigration visa in the first place are people who are tourists. So people who are from an area or a country where they're able to enter on the visa waiver program and then just overstay, they're able to adjust their status. They're not subject to these inadmissibility bars versus people from, again, these poor countries where we don't give the visa waivers to. So those tend to be countries from Central America, South America, Africa, as well as Arab countries, are not able to take advantage of that. So they're the people who tend to be subject to this bar. And then the third way in which the law is not necessarily race neutral relates to the discretion in enforcement of immigration laws. And so what's evolved over the years is a system in which there's very little oversight and limited remedies for non-citizens when immigration officials or officers actually explicitly profile them because of their national origin or their race, or take actions against them, right, because of their national origin of race or race. The Supreme Court has repeatedly said in decisions that in the context of immigration, national origin isn't, as a basis for making decisions, isn't subject to this higher level of review that the court normally subjects it to. It's subjected to something called rational basis. So basically, any reason that the government can come up with to have done this and why they needed to base something on national origin, the court's going to defer to that reason. So any of you who followed the travel ban cases, that's really a lot of the rationale or reasoning that went into the travel ban cases, because they were reviewing it under this lower standard, saying even though there were statements that might have been aimed, right, at people from Muslim majority countries or Arab countries, it's not unconstitutional because the government has stated a reason for it, security, right? So what that's resulted in, like I said, is just a lot of discretion and little oversight. The other aspect of the law is that individual immigration officers are given tremendous discretion in how they exercise or enforce the immigration laws. So an individual Border Patrol agent at the border gets to make a decision on the spot about whether that person has done something that would make them inadmissible. And so that can result in these individual decisions that may be motivated by bias, either implicit or express. So ProPublica recently reported on a case that was in immigration court. It was in a compilation of cases that they reported on. And this was a case that arose out of a 2017 workplace raid in a poultry transport company. And what had happened is Immigration and Customs Enforcement showed up at this poultry transport company. They didn't have a warrant. They passed all of the signs that said no trespassing and blocked all of the entrances. As employees came out of the processing or the transport company plant, immigration officers, according to witnesses, only stopped people who looked Latino, and also stopped white employees and asked those employees to lead them to additional Hispanic or Latino employees. In immigration court, the immigration judge said that there actually was a strong argument that the ICE officers had, quote, egregiously violated the Constitution in basing their, who they were going to question on the national origin. But it didn't matter to the deportation case. So the people were still deported anyways because of the way that the immigration laws are set up. You're not able to suppress that kind of evidence to the same extent that you would in criminal court. Okay, so those are the myths, and now I want to talk about why it matters. So there's 3 harms, I think, that really result from the combination of these myths. And so the first one is that it's destructive to public discourse. So, right, using terms like alien, which literally means the other, and illegal to describe a whole group of people, doesn't really lead to productive dialogue about how to form our immigration policy or who should be at the table to make these decisions. So demographers Douglas Massey and Karen Prinn did this study in 2010, and what they documented was this Latino threat narrative that presents migrant inflows to the United States as being a threat to our national security and to our borders. The narrative is developed over decades, and it ends up being fed by media accounts. And so then that has led to explicit policy decisions in Congress to further limit immigration. And I think one of the ways we've been seeing this most recently is in some of the coverage or discussion over the migrant caravans and the choice in language that people are using to describe the migrant caravans. And so just calling it even maybe a migrant caravan is making a choice about how we think about these people who are fleeing violence and trying to seek refuge or asylum in the United States. The second thing, right, is that it can lead to bad policy. So I have 3 examples. I think there's a lot more, but here's 3. So first is that changes to immigration law can often lead to unintended consequences. And when people are operating on stereotypes or inaccuracies, they don't have the ability to fully think through those consequences and what they might be. So as an example, I mentioned in 1965, when they ended national origin and racial-based categories of exclusion and imposed caps on immigration, what that did is it actually led to an increase in the unauthorized Mexican population. And this wasn't because all of a sudden there were more people from Mexico immigrating to the United States. It's because when Congress did that, they limited the number of visas that were available without accounting for the normal migration flows that we had from Mexico over the course of a century. And it left the enforcers of the law or people who are governed by the law with few ways to be able to match visas to the numbers of the people that normally would come. So that's one example. Another example is a recent choice to increase prosecution of non-citizens for this relatively minor crime. It's a federal misdemeanor for entering without inspection, and that's under Jeff Sessions' zero tolerance program. And so what that's already started to result in is a sharp decrease in prosecution for other crimes that occur along the border. So things like drug trafficking and human smuggling and weapons smuggling. So in March 2018 of this year, the non-immigration offenses accounted for 1 in 7, so 14% of prosecutions along the border. In June 2018, they were down to 1 in 17, so only 6% of prosecutions. So, the result has been that there might be less prosecutions of crimes that people might view as being more serious, where we want our government dollars to go to. But of course, that's not a conversation we're having necessarily because of some of the problems with public discourse created by these myths, or at least not everyone understanding the immigration system. And then the third public policy problem is that what's resulted is we're not really doing a good job of either planning prospectively for U.S. immigration needs or even post hoc for emerging immigration needs. So this is related to, we used to adjust our immigration system with these regularization programs or amnesty programs to recognize what we needed in the US based on these inflows of immigrants. We haven't had a regularization program since 1986. So that's a long time to go without any sort of adjustment and only restriction. So we have a system that's not actually meeting our needs. Okay, so then the third harm is that it creates this unjust and inequitable treatment of non-citizens, but their family members and their community. And I have 3 points there. So these myths or misperceptions of immigration, they can do things like increase intergroup bias, and because they're categorizing non-citizens, and especially non-citizens of color, as being the other. And the words we're using to describe them, talk about them, think about them, increase that perception. The other is that it also can lead to this narrative of deserving versus undeserving immigrants that leaves anyone we categorize as the undeserving out. And third, it categorizes people as lacking agency or power in ways that can lead to their further exploitation. So I want to briefly talk about each of those quickly. So the first is this idea that when we rely on these stereotypes or this inaccurate information, it can allow the predominant or the superordinate group to further otherize a whole group of people by calling them illegal or criminal, and that results in justifying treatment for all sorts of things. Things like keeping people in detention for years before they get their immigration hearing. Things like separating children from their families and adopting them out to more deserving families. Things like putting babies or even 2-year-olds in immigration court proceedings without a lawyer. So these are the kind of things that can result from being able to increase this intergroup bias and categorizing people as being part of the out group. For other points, right, even advocates of immigrants can fall into some of these traps, right? So there was this whole narrative that developed around especially DACA recipients, deferred action for childhood arrivals. So one of the talking points we would often hear is they were brought here through no fault of their own. Well, one of the problems for DACA recipients that came up is whose fault was it then? Their parents, right? So they're being asked, to justify, right, their ability to maybe get legal status or discretion by categorizing their parents as having done something wrong. Another way that this can happen, or the third point I was going to say, is taking away agency or power from people by viewing them maybe more as victims or passive actors. One of the examples I can think of this is the narrative or the rhetoric that's out there is that we need immigrants to do jobs that no one else will do, right? And so what's the idea behind that? The idea is, well, if they'll do jobs and they need them so badly that other people can't do, then I as an employer can exploit them because they really need this job. So that's the ways I think that the policy can result in unjust and inequitable treatment. Okay, so now I wanted to just talk about some things that I think that we all could do that maybe to combat some of these harms. So one, I would say, that's easy to start with is don't use the term illegal alien or illegal immigrant. That's an easy one. The next is remember that immigration policy is incredibly nuanced, and try to resist putting people into categories and creating these dichotomies between deserving, undeserving, victim, perpetrator in ways that can actually harm or undermine people. The third thing I would say is learn about and share your own family's immigration story. By doing that, right, we can build across boundaries. We can help recategorize today's non-citizens as not being that much different from our ancestors or our families that came to the United States. And it can help us maybe create more shared frames of references that could help us engage in more deliberative policy choices. And then the final thing I would say is that a useful strategy can be to ask questions of people when you're in a conversation with them about immigration that helps them maybe think about where are they drawing stereotypes, where might they be making false assumptions about immigration law. So questions just like, what do you think the law requires now? Or what did you think it required when your family immigrated? Or on what do you base that, right? And listen to what the other person is saying. You could also ask someone, what would you have done in that situation, maybe depending on who you're talking about. That's my challenges, I guess, and the presentation. And I think I have about 10 minutes for questions. So I'll take questions now. Thank you.
We have a microphone that I can pass around, and if you would prefer to ask questions of Angela, she will be in a breakout session next too, so if you have different questions. But my lovely colleague Scott Bates can pass around the microphone if people have questions. Comments, concerns, queries, burning ideas?
Hi, thank you for being here.
Thanks.
I just have a question about, what you foresee happening with the cap. As you know, premium processing has been suspended for businesses. Of course, it doesn't affect us here in higher ed, but I was wondering, what do you foresee as far as a business repercussion for doing that? And do you feel as though that could be lifted because of those repercussions?
Yeah, so I think what you're talking about are the caps on, there's non-immigrant visas available for some people who come in certain fields. So they're HB2 visas, right? Is that what you're thinking of? And that are limiting people, especially I think where it's impacting is Silicon Valley and engineering and things like that. So those were visas that were temporary that could often allow people to adjust to one of maybe these main visas. So yeah, I mean, as far as for businesses, there's already an issue with the long waits, right? So imagine being a business, having to try to plan out your workforce 5 years into the future and figure out what your needs are going to be. But for the suspension of those visas or the reduction in the number of visas that are available, that's going to create real problems, I think, or what a lot of experts who study that area are saying as far as worker shortages. The other thing, I think it might impact higher ed, right? So you think about about international students that are coming to study. A lot of times what they do immediately after graduating is get one of these non-immigrant visas that then translates into the longer-term employment-based visa. So I mean, one of the things like that you hope is that maybe there will start to be the backlash against it maybe, and that policy will be reconsidered. I mean, on the other hand, right, we could find out that maybe there are actually US citizens or legal residents who would take up those jobs, but it might mean paying higher wages. That was a long answer, but that's what I think, yeah.
Hi, Angela. Thank you so much for a very informative talk.
Okay.
Would you talk a little bit about the role of language as you see it in there, especially English learning in that, and the legalities involving that?
Sure, there's so much to say there. So as a lawyer, my trade is language, and especially in immigration law where you have to pay particular attention to the statutory language and interpret it to figure out what it means. But I think the bigger question is how we talk about other people and the narratives and the rhetoric, right, that we use to refer to other people is going to change perception. And this is why that one study by the demographers was so interesting to me about tracing this like rise of the narrative that really did start with things like calling people illegal aliens, talking about this false idea that immigrants commit more crimes, which allowed them to enact more restrictionist policy. So I think what's unclear is, what was unclear for me sometimes was, sometimes did the restrictionist policy, it was a cycle. So it feeds on itself. So the more restrictionist the policies get, the more people there are that are outside the immigration system. And so there are more people that you can call these terms. I don't know if that answered the question about language, but studying language is important.
I think I'm live. Okay. I just want to say thank you for being here. I work in our international office, and I think, you know, for people to know some of these myths that you speak about, because where it does kind of hit the road is all of these issues impact our ability to bring international students, which also impact our ability to have a diverse campus. And so I think, you know, talking about the ability to have employment and lawful employment, I don't know how many times I've corrected people who've been like, oh, they're working illegally. How do they have these jobs? And not understanding what their visa allows them to do. So thank you.
Oh, sure. And I was going to say, one of my students at the law school came, she's Chinese, and it was in her first year, was about the time that the travel ban was enacted. And she did come up to me and say, I feel really unwelcome in the United States. I mean, naturally, right? So I think that's the other problem, is not even just the idea that we want to make sure that our students have jobs and can come here and study, but also how they feel and how included they feel in our community. I think there was another hand here.
All right, our last question. I ask you to pass this.
I got it. It's a race.
Okay.
Thank you so much. My question has to do is, are you aware of any training that's happening to help those that are in, like adjudicators that are processing immigration forms, or ICE employees, or anybody? Is there anything happening to help them avoid unconscious bias as they process documents or as they interact with individuals at the border?
So under the last administration, they had started to do some of that training across all agencies within DHS. From what I understand, that those efforts are not, that they're not doing that kind of training anymore, yeah. But it's a good idea.
Please join me in thanking Professor Morrison for her comments.